And that is the end of Symphony Number 5 by Beethoven. And if this were a radio show, then I think I'd make a very good local radio DJ. Yes, that was Beethoven with his latest smash hit, his Fifth Symphony. And now we go to local news. Maybe not. All right, so welcome to the stream. Those of you who are here, those of you who may be watching later, welcome to the video. This is something new, I suppose. It's not scam baiting, which those of you who know my previous content is what you'll know me for. This is going to be something a bit different. We're going to take a look at a statute that was recently passed in the United Kingdom, just to see, exactly what new powers the police have in light of the COVID-19 crisis. Some people are saying it's a police state and whatnot. So I thought what we would do is watch a couple of videos first, just to they're quite short. There's two videos. Oh, I thought I'd lined up a third one. Hang on, let me just rack that one up as well. Let me see. Derbyshire Police drone. All right, maybe that's going to be in the other video. Right, anyway, so let's we'll see. So I suppose this says it's 1080p, this first video, which doesn't look like it to me, but we'll give it a chance. Maybe it is. So let's have a look and see what this person has to say. So this is a video about the police stopping and fining drivers in the UK for what's being classed as non-essential travel, which is a phrase that is being used quite a lot at the moment in the United Kingdom. So let's give this a quick listen. It's only a minute long.
They follow the measures, they follow the guidance. The police are out and about already. The point now is that as of today, the police have enforcement powers, and those powers involve the ability to level a fine, and that fine will increase if people do not comply and do not pay that fine on time. And that'll be based under the fixed penalty notice and the regulations that are now coming into place today.
I'm just going to pause it there. She's raised an interesting point, and I'm going to come back to this. It's probably just sloppy language use, but it is an interesting point. We'll come back to this later.
What we want to be able to do is illustrate to the public that we're doing our very utmost as all emergency services to try and protect the NHS and to try and save lives. Let me know how the audio levels are. We hope that we will not have to enforce the powers.
I hope they're fine.
What we hope is that the public listen to those restrictions and they stay at home.
Right, okay. So there wasn't much content there. We're going to take that back.
Regulations that are now coming into play, and that'll be based under the fixed penalty notice.
So she earlier referred to them as a fine. Now, a fine and a fixed penalty notice, in law, they're actually different things. Now, if she's talking about fines, she's actually, you can't do that. Now, let me see. Promises of fines and forfeitures. Now, all right. Well, I mean, I suppose Bill of Rights. There we go. That's what it is. Right, so I suppose this brings us on to an interesting point for any American friends that may be listening. It's often stated that the United Kingdom doesn't have a constitution. And this is actually incorrect. We just don't have a single constitutional document that's called the Constitution. What we have are constitutional statutes. And these constitutional statutes cannot be repealed, implied, like they can only be expressly repealed if it, like, so they have to be named in another statute, and it has to be said this section of this statute is being repealed. And if it doesn't do that, like the other sections of the constitutional statute are still legal, still in full force and effect. Yeah. So Bill of Rights 1869. Is it? Right. Was it 1689? Yeah, 1689. So now there's a section in the Bill of Rights which is still in full force and effect, which basically says that, here we go, promises of fines and forfeitures before conviction are illegal and void. Now, in the way that they get around this in the UK is that they class fines as fixed penalty notices, but she's kind of, you know, so, and I'm guessing this is just she's speaking colloquially, she's not speaking.
As of today, the police have enforcement powers, and those powers involve the ability to level a fine, and that fine will increase if people do not comply and do not pay that fine on time.
Right, so that's not a fine, it's a fixed penalty notice, and they are different things.
And that will be based under the fixed penalty notice and the regulations that are now coming into place today.
So that means that actually, if it's a fixed penalty notice, it means that there's going to be an appeal procedure. So it's not, you know, when they're saying that people are being fined, it's not like people are being fined. I mean, maybe they are being fined on the spot. Okay, anyway, let's move on to something else. Police drone. Let's put COVID-19 in. Well, okay, I mean, let's just, maybe this is, there's no audio probably, so that's fine. Let's full screen that. Now this is a video that was, all right, this has actually been put out by Derbyshire Police, right? So they've got a drone, and now, like, they're targeting people. And they're also telling you what's essential and why. But here's an important, you know, they don't know who these people are. Going out of your way for an Instagram snap, not essential. But it's like driving to a beauty spot for a stroll, not essential. So it's interesting. Now, if it is essential, okay. Now look, these guys are quite far apart from each other. I mean, there are a few people here. You know, there's a person here, there's a person up there, there's one there. It looks like these might be shadows, maybe. No, that's moving. I think that one's a shadow, but this one's moving. So, okay. So it's quite interesting that now there was a Newsnight thing here. Is this the Newsnight? This is quite long, so we're not going to watch all of it because I want to get to the statute so we can have a look at what the new provisions are. But
Alison Codd and Sergeant Colin Batchelor are doing their usual beat in Weston-super-Mare on a weekend they've never seen the likes of before.
Now, Weston-super-Mare is a coastal town. It's, you know, April now, so we're kind of moving towards the tourist season. So while it might not actually be full of tourists, you would expect there to be some people here.
They seem quite organised, everyone behaving themselves.
This is policing with a difference, enforcing rules that weren't rules just days ago.
And that you saw there, let's again just take it back. This is quite a common sight in supermarkets now. So
everyone behaving themselves.
This is policing with a difference.
So these guys here are all 2 meters apart now. They in the city that I'm in, they actually put tape on the ground, which they've measured out at the appropriate distances. And this is happening inside supermarkets as well. So like queues are being demarcated, and they move around the store.
Right now,
the first call is to check on someone sleeping on the street.
We'll head there and.
So, and I think this is an interesting point, I suppose. You've got this virus that's spreading. You're telling people they have to stay at home. What about the homeless people?
Just make sure he's okay.
The government said on Friday that no one should be homeless during this lockdown.
Right, so there's an interview with the homeless guy, which is quite,
not today.
like it's quite, it's quite a good interview. I'm going to skip it though, mostly because like this isn't kind of critiquing this video as such. I just want to, there is an interview with, I suppose I do want to see some of these interactions, though, not with the homeless guy. Let's kind of skip
on the
this.
Beach, the police see a long queue outside a pharmacy. Many of these people are desperate to get prescriptions either for themselves or their families. We spoke to NHS and social...
Again, notice they're kind of... I mean, it's not marked out or anything, which if you're expecting people to queue, I think would be sensible.
Care workers who couldn't get the medicines they needed. Jamie Lee's experience was typical of people in the line.
Right.
Got here about 25 to 10.
And how long have you been here for?
Over 2.5 hours. Yesterday it was moving on.
Right, okay, so that's...
Last week, Derbyshire
Here we
police
go.
were criticised after releasing drone footage targeting people driving to walk their dogs. Many on social media said the police had gone too far. But the government has clarified the rules you are supposed to exercise near your home.
You shouldn't be driving unless it's essential for bringing your dogs. Have you seen the Home Office guidance on it?
So, and this is what's happening, I suppose, in the UK. Now, I've not seen this happen, but, you know, obviously they're filming this happening. We now got the police who are questioning people who are going about their business, which I think is kind of interesting. It's an interest, like, because in the UK, really, unless you're suspected of having committed a crime, you're kind of under no obligation to interact with the police, right? Like, you don't have to give them your name, you don't have to talk to them, unless they're wanting to get a statement from you. And even then, like, I don't know if you have to, I mean, you know, the right to silence is a thing, right? So, anyway.
Excuse me?
But it's like also the right to not have to tell the police what you're doing if you haven't broken the law. But of course, you know, is going for a walk breaking the law now? Or is going for a drive breaking the law? This is going to be an interesting time.
Hi, sorry to bother you. Have you driven here? Good answer. Just come up walking the dog. Right, okay. The only thing we'll say is please read the government guidance on essential.
I mean, these guys are being quite polite, you know. That's kind of good. But I mean, they've got cameras on them, obviously.
Here, really, just to have a will.
Now, let's skip
role
ahead.
Is clearly to make sure the
It's very clear that it's our role to educate and encourage.
And that's good to hear. You know, it's their role to educate and encourage. You know, policing by consent and all that kind of stuff. I like his little bottle of hand cleanser there. That's nice.
Before we go to enforcement.
That's the
last option for us.
All right, so this is
to
kind
remind
of
officers that they cannot bar people from going for a run or a drive. Joining me now from Somerset is Andy Marsh, the chief.
Now, she's going to make reference to something that a judge said. Okay.
What we want to be able to do is illustrate to the public that we're doing our very utmost as all emergency services to try and protect the NHS.
Right, okay, no, well, this copper's going to talk about that. I thought there was maybe an interview with the judge, but is this the one? Former. All right, here we go. So let's see what the judge has to say.
Shaming citizens for travelling at what they see as the wrong time or driving to the wrong place. Does that set alarm bells ringing for you as a former senior member of the judiciary?
Well, I have to say it does. I mean, the tradition of policing in this country is that policemen are citizens in uniform. They are not members of a disciplined hierarchy operating just at the government's command. Yet in some parts of the country, the police have been trying to stop people from doing things like travelling to take exercise in the open country, which are not contrary to the regulations, simply because ministers have said that they would prefer us not to. The police have no power to enforce ministers' preferences, but only legal regulations, which don't go anything like as far as the government's guidance. I have to say that the behaviour of the Derbyshire police in trying to shame people into using their undoubted right to travel to take exercise in the country and wrecking beauty spots in the fells so that people don't want to go there is frankly disgraceful. This is what a police state is like. It's a state in which the government can issue orders or express preferences with no legal authority, and the police will enforce ministers' wishes. I have to say that most police forces have behaved in a thoroughly sensible and moderate fashion. Derbyshire police have shamed our policing traditions. There is a natural tendency, of course, and a strong temptation for the police to lose sight of their real functions and turn themselves from citizens in uniform into glorified school prefects. I think it's really sad that the Derbyshire police have failed to resist that.
All right, so there we go. The police have some powers, but what the police can't do is do what the Derbyshire police did. Now, I think maybe I'll skip the rest of this. If you want to watch this video, it's BBC Newsnight, and they're kind of on the road with police enforcing social distancing. So, go and have a watch there. Fuck the police. Right, so now let's get to why I'm here. Although this is quite a lot of talking, it's going to involve quite a bit more talking. As you can see, this is what we're going to be looking at. Let's just do that. Okay, so I think what I might do is go and make a cup of tea, because it's been half an hour, and I could do with a cup of tea before we get to the kind of real meat of what we're going to be doing for this stream. Maybe you should do the same, because it might take a while. So let's very quickly put some copyright music, free music on. Let's have some more Beethoven. This is another 5 minutes tune, so it's not too long, and I don't have to say anything about it. All right, I'll be back shortly. All right, so I'm back. I have my cup of tea, and let's get into this. Right then. This is the Coronavirus Act of 2020. Let's do latest available, just in case there have been any changes and whatnot. Right, so it's quite a long document. We're certainly not going to go through all of it. We're in fact, compared to how large the document is, we're probably going to go through relatively little of it, right? Especially seeing as in order to get an understanding of what it is that we're reading, we're probably going to have to make reference to several other statutes. So it's going to be boring. It's probably going to be complicated and dull. Not all grey. No, it's just builders. You know, black 2 sugars. Yeah, Yorkshire tea. I'm a fan of Yorkshire tea, although we do have Earl Grey. But anyway, it's going to be largely dull and incomprehensible. So yes. So let's get on to the first thing, which is interpretation. So let's open you up and have a look here. Now, I was on a panel the other day with Lady Di, and she made an interesting and, in light of this, rather startling claim, which is that COVID-19 is a mutation of SARS-CoV-2. And so the United Kingdom government seems to be saying something different. I'm kind of glad this is in here because it's a nice rebuttal to what she was saying. So in this act being the Coronavirus Act 2020, coronavirus means severe acute respiratory syndrome, coronavirus 2, SARS-CoV-2, all right? Now, coronavirus disease means COVID-19, the official designation of the disease which can be caused by a coronavirus or by coronavirus, right? So COVID-19, so SARS-CoV-2 and COVID-19 are actually referring to 2 discrete phenomena, right? So Lady Di, if you see this, Lady Di, and I'm going to point this. If I come onto one of your live streams, again, because she was kind enough to invite me onto her panel, and so if that ever happens again, I am going to have to bring this up because what she was saying was definitely wrong. Right. So there are actually 2 different things. SARS-CoV-2 is the respiratory syndrome coronavirus, right? Coronavirus disease is the disease which is caused by the virus. Yeah, right. But Lady Di thinks Trump talks to her through the TV. Well, presumably Trump talks to everybody through the TV. I mean, well, quite a lot of people. I mean, she's right. You know, Trump is talking to her through the TV. It's just that he's also talking to everybody else who's watching. Okay, so a reference in this act to infection or contamination, however expressed, is a reference to infection or contamination with coronavirus, right? But a reference in this act to persons infected by coronavirus, however expressed, does not, unless a contrary intention appears, include persons who have been infected but are clear of coronavirus, unless reinfected. Okay. So you get this at the start of virtually every British statute, where you know you have a kind of, and often in sections as well, they'll have specific definitions for terms, and so he communicates with her. All right, so this is all kind of stuff to do with registration of health professionals, which isn't really pertinent to what we're looking at. Yeah, so all right, now there are some interesting things. Investigatory powers. Now, I'm not entirely sure what this is. Appointment of temporary judicial commissioners. What does that mean? Let's have a look. All right, the power in subsection in subsection 2. I'm guessing that's this. The Secretary of State, all right, is exercisable if the Investigatory Powers Commissioner notifies the Secretary of State that A, as a result of the effects of coronavirus, there is a shortage of persons able to carry out functions conferred on judicial commissioners. All right, so I suppose it'd be worth finding out what is a judicial commissioner. Is that going to have any effect on what we're looking at? I mean, this could be the subject of another stream, maybe. The 13 judicial commissioners will continue the approval work of the former surveillance commissioners, and in due course will continue what? Right, I don't know what that is. That looks like another rabbit hole. Maybe I'll look into that. Maybe it's just going to be some kind of legalistic dead end that doesn't actually mean anything. But okay, so what does this mean? Well, what does this mean? The Secretary of State, the power in subsection 2. Let's go back. Let's go back. The power in subsection 2. Investigatory powers. What does it say here? Alright, okay, that's actually what we're looking at. The regulations must provide that a temporary commissioner may be appointed for one or more terms not exceeding 6 months and not exceeding 12 months in total. Well, I don't know what a judicial commissioner does, so I don't know how important that is to look at the moment. Time limits in relation to urgent warrants, etc. under Investigatory Powers Act. Right, okay, so subsection 2. The Secretary of State may, by regulations made by statutory instrument, yeah, you got a lot of language, haven't you? Modify the Investigatory Powers Act of 2016, okay, so as to alter, for the purposes of any of the specified provisions of that Act, see subsection 3, length. See subsection 3. The length of a period referred to in that Act as the relevant period. This is why nobody understands the law. This is why normal people don't understand the law, because it's written in such a way that it's kind of incomprehensible. Right, what's urgent warrant? I suppose I don't know what that is, so let's have a look. Urgent warrant, UK law. Oh, it's a search warrant. So maybe this is, this might be something worth looking at. Right, okay. The specific provisions are of the Investigatory Powers Act. All right, so let's have a look at the Investigatory Powers Act then, just to see what that's saying. 2016. Oh, right. Okay. Oh, this is interesting. All right. So, what is the Coronavirus Act 2020 potentially changing? Sections 24, subsection 3. All right. Let's have a look. Sections 24. Approval of warrants in. All right. Well, this would make sense. All right. So this is to do with the approval of warrants in urgent cases. I mean, I suppose it's like any other technical language, Tarquin. It's like, I would imagine it's very useful for people who draft statutes or have to work in the law every single day. It's just difficult when you get something that's written in legalese, but someone who only really speaks and understands English trying to interpret it. Okay. So are they saying, is this the Coronavirus Act, a modification made by the regulations may not increase the length of a period so that it ends after the 12th working day after the day on which the warrant was issued, or as the case may be, the modification was made? Right, so I'm guessing there's a time limit on how long an emergency warrant can last. Right, here we go. Yeah. Okay, right. So approval of warrants in urgent cases. So they're extending from three working days. Is that right? This section applies. So this is the Investigatory Powers Act, 2016. The approval of warrants issued in urgent cases. Oh, this is the original. Oh no, we want the latest version. This section applies where a warrant under this chapter is issued without... When was this made? There are no currently showed timeline of changes. Alright, so there are no changes. Is that what they're saying? Okay. In that case, original as enacted. It doesn't really matter. This section applies where a warrant under this chapter is issued without the approval of a judicial commissioner, and the person who decided to issue the warrant considered that there was an urgent need to issue it, so a judge, presumably. The person who decided to issue the warrant must inform a judicial commissioner that it has been issued. The judicial commissioner must, before the end of the relevant period, decide whether to approve the decision to issue the warrant and notify the person of the judicial commissioner's decision. Okay. And the relevant period is the 3rd working day after which the warrant was issued. So they're extending that from 3 days. So 3 days to 12 days, if I've understood this correctly. Right, so a modification made by the regulations may not increase the length of a period so that it ends after the 12th working day after the day on which the warrant was issued, or as the case may be, the modification was made. The regulations may make consequential, supplementary or transitional provision. Okay, right. The regulations must provide... So I think that that's saying... The regulations may then further make further... What's a transitional provision? Oh my god, it is nonsense. The regulations must provide for them to cease to have effect at the end of the period of 12 months, beginning with the day on which they come into force. Right, okay. Right, so presumably that's if they're... So that's presumably if you make like consequential or supplementary warrants. I mean, I'm guessing consequential because... Right, okay. A statutory instrument containing regulations under this section is subject to annulment in pursuance of resolution of either House or Parliament. All right. In this section, Investigatory Powers Commissioner has a meaning given in... All right, Section 263, subsection 1 of the Investigatory Powers Act 2016. So, Section 263, that's going to be way down here. Oversight arrangements, miscellaneous and general provisions. 263, general definitions. All right, okay, let's have a look. General definitions. Enhancement to yada yada yada. Judicial Commissioner means a person appointed under Section 227, subsection 1A or B, and the expression is therefore to be read in accordance with subsection 227. No, Section 227, subsection 13, paragraph A. I think that's how you read these things, right? So it's Section 227. Subsection 13, paragraph A, and we can go to that. Okay, let's go to that. Oh, is that... This is the same thing, right? Okay, Section 263. Right, okay. Means a person. I mean, notice how they don't tell you what it means here. You have to go to section 227. Are you kidding me? Are you fucking kidding me? Yeah. 227 was it? I did say this is going to be a deep dive. 2271A. 2271A. All right. Okay. Back. 227. That's assuming it is this act. 2271A. What the fuck? It doesn't actually tell you what it is. Right, okay, fair enough. It's just the point, the person appointed, right, okay, to be that person. Of course, right. So that's interesting. They're extending, if I've understood it correctly, and I might not have understood it correctly because, one, I'm not a fucking lawyer, right? None of this is legal advice. And two, I'm a bit of a fucking idiot. So, you know, it's important to bear that in mind. But it does seem like they've extended the length of time that you can have an emergency warrant from 3 days to 12 days. So that's a thing. Right, what's this? Extension of time limits for retention of fingerprints and DNA profiles. Right then, well, this looks interesting. Let's have a look. Hey Guido, welcome to the stream. So, extension of time limits for retention of fingerprints and DNA profiles. This section applies to fingerprints and DNA profiles that are retained in accordance with a national security determination under any of the following provisions. So the first one being Section 63F of the Police and Criminal Evidence Act 1984, retention of Section 63 material. Right then, Police and Criminal Evidence Act 1984. What section was that? That was 63F. 63F, retention of Section 63 materials. Persons arrested for or charged with a qualifying offence. So, okay. Hey Pookie, welcome to the stream. So, retention of Section 63D materials. What are Section 63D materials? 63D. Destruction of fingerprints and DNA. Alright, so there's fingerprints and DNA profiles. So this, so that's fingerprints taken from a person under any powers conferred by this act, or prints taken by the police with the consent of the person from whom they were taken in accordance with the investigation. Okay. Or a DNA profile derived from a DNA sample taken as mentioned in paragraph A1 or 2. Right. So I think we can ignore the rest of this. It's basically DNA samples and fingerprints. So what are we looking for? The length of time. The retention period. Okay, here we go. 3 years for fingerprints and 3 years for DNA. Right, okay. An order under subsection 7. Is it this one? The chief... Alright, so the responsible chief officer of police or a specified chief officer of police may apply to a district judge in the magistrate's court for an order extending the retention period. And they can do that, an order under within the period of 3 months ending on the last day of the retention period. So 3 months after, within 3 months after the last day of the retention period, they can make an application to extend it by a period of 2 years. Okay. The following persons may appeal to the Crown Court against such an order or a refusal to make such an order under subsection 7. Okay, so that's, I think we can ignore the rest. All right, okay, no, hang on, what's this? In this section, all right, okay, excluded offence. Where does that come into it? All right, let's go back. So this is, you do need to actually read anything. In connection with the investigation of an offence, if the person has been previously convicted of a recordable offence, which is not an excluded offence. Okay, so what is an excluded offence in relation to a person means a recordable offence, which is not a qualifying offence, is the only recordable offence of which the person has been convicted and was committed. Right, okay, so all right, so it's saying that right, so have I understood this? Have I understood this? Reference to recordable offence. All right, okay, so this applies to materials for people who have been charged with a qualifying offence but is not convicted of that offence. Okay, I think if you've been convicted, they can keep it forever. Maybe we might need to look into that somewhere else. But right, so that's, they can keep stuff for 3, assuming you haven't been convicted of an offence, they can keep stuff for 3 years, right? All right, paragraphs 20 or schedule of, okay, let's have a look at this. There's schedule 8 of the terror. All right, let's have it. What's this? The terrorism. No, I don't want that page. I want the legislation. Right, so it's just the Terrorism Act, isn't it? It's just the Terrorism Act 2000. It isn't. It's not written to be understood by human beings. No, certainly not. So, what section are we looking for here? We are looking for paragraph 20, B or C of Schedule 8 to the Terrorism Act 2000. So let's have a look at that. Schedule 8. So let's collapse you. We don't need you. We don't need you. We don't need you. We don't need you. We want the schedules. They're normally at the end. All right, Schedule 8. Schedule 8 of the Terrorism Act, paragraph 20B or 20C. Right, so this is, again, I mean, I'm guessing this is just going to be a fairly dry... okay, here we go. 20A and 20B. Is that right? 20B and 20C. Sorry. 20B and 20C. All right, so that is 20A. We don't need you. Goodbye. 20B. This paragraph... so what is this? This is the Terrorism Act. So is this defining what is a terrorist? Okay. Again, notice that the retention period still is 3 years. And again, it may be extended by a period of 2 years if they make the relevant application for extension, which has to be made 3 months, within 3 months. Right, okay, so it just seems, I'm not going to get into what is a terrorist. That could be, again, a whole other stream. And this is the same for, all right, Scotland. Yeah, okay, fair enough. All right, so that might be different in Scotland. Let's have a look. Retention period. Retention period is, wow, 6 months. Let's all move to Scotland. And 6 months for DNA. Right, okay. So this is the Terrorism Act. We can close these. Just want to get rid of some of these tabs. Right, okay. Section, all right, I'm not going to go through what these are. I haven't committed an act of terrorism, but I suppose the section applies to people arrested under those acts. Right. So this applies this section applies to fingerprints and DNA profiles that are retained in accordance with a national security determination under any of the following provisions, and then before being destroyed under the following provisions. Right, okay. And that's to do with the destruction of relevant physical data and destruction of fingerprints and whatnot. Right, so the Secretary of State may make regulations extending for up to 6 months the period for which the fingerprints and the DNA profiles may be retained. And this is of people who have not been convicted of a crime. Right? Coughing on a policeman while saying you have COVID-19 is now classed as an act of terror. Oh, really? Oh, maybe we do need to look at that. Can you find a source for that, Tarquin? Can you do me a favour? See if you can dig out a source for that anywhere. I'm going to carry on with this. So the Secretary of State may make regulations extending for up to 6 months the period for which the fingerprints and the DNA profiles of people who have not been convicted of an offence, right? So they're not criminals, may be retained. Now, this doesn't mean that the Secretary of State, that the government can actually keep hold of the profiles. I think it's just saying that he can make regulations if he wants to, but he can do that anyway. But I don't know. All right, okay. Let's carry on. The Secretary of State may exercise the power under subsection 2, which is this power, only if the Secretary of State considers that coronavirus is having or is likely to have an adverse effect on the capacity of persons responsible for making national security determinations to consider whether to make or renew national security determinations. Okay. And it is in the interests of national security to retain the fingerprints or DNA profiles of the people who have been arrested, presumably under this act, but not convicted of a crime. The power under subsection 2 may be exercised on more than one occasion, right? But not so as to extend the period for which any fingerprints or DNA profile may be retained by more than 12 months in total. Right, so I think what this whole thing here, these subsections, right? So have I understood it correctly? I think they're saying the extension of time, is this the same act? Is this what we're looking at still? All right, yeah. So currently, the state can hold your fingerprints and your DNA for 3 years in England and 6 months in Scotland. And then the Judicial Commissioner can make an application to extend that by up to 6 months. 2 years, right? And assuming you've been arrested under any number of statutory provisions. Right, so the Secretary of State can make regulations to extend that period for up to 6 months. And he can do it on more than one occasion, but he may enact legislation to extend the period for no more than a period of 12 months. So what they're doing here is they're giving themselves wiggle room, right? This is kind of legal wiggle room. So with this in play now, the Secretary of State can kind of do this. He can do this without having to enact another piece of legislation. So it's like this is like shadow legislation, right? These are like shadow rules. So this isn't saying these rules are now in place. This is saying that he can make rules to extend the length of time for which fingerprints and DNA may be retained. Right. Okay. So let's carry on. The Secretary of State may the power under subsection 2 to extend the period. Okay. Yeah, we've read the subsection 4. Subsection 5. The power under subsection 2 may be exercised only in relation to fingerprints and DNA profiles which, ignoring the possibility of an extension otherwise than by regulations under that subsection, would need to be destroyed within a period of 12 months beginning with the day in which this act is passed. Right, so only it could essentially be a dictatorship. So, oh right, so this is from the Crown Prosecution Service. Let's have a look at this. Right, so okay, charged as assault. That's not terrorism, I don't think. Yeah, all right. Okay, I mean that's something that we could look at as well in a bit. But again, I'm going to maybe save that for a later stream, perhaps, or you know, later in this stream. I want to continue with this. Oh, USA. What's the USA? Oh, I see. It's the same thing.
Definitely tested positive.
Oh, right. Oh, right. So it's in the US. Okay. Again, we can maybe look at that later. Given how far we've gotten into this, I don't think that's likely, to be honest. Right. Let's go. Let's carry on. Subsection 5. Right. So yeah, the powers to extend the length of time. That's saying that if he makes a rule saying that they can keep DNA samples for longer or fingerprints for longer, that only applies to those profiles that would have to be destroyed, right? So I'm guessing that's if you've not presumably convicted criminals, right? Just people who've been arrested. Before making regulations under this section, subsection 6. Before making regulations under this section, the Secretary of State must consult the Commissioner for the Retention and Use of Biometric Material. All right, okay, fair enough. That's just going to be a government office. I'm not even going to bother looking that up. Right, if the Secretary of State has not exercised the power under subsection 2 before the end of the period of 3 months, beginning with the day on which this act is passed, this section ceases to have effect. I think that is that saying. Right, I think that's saying that he can only exercise the power to enact regulations to extend the length of time that the state can keep hold of biometric data 3 months, like within 3 months since the passing of the act, which was, I think, the 25th of March. That's just off the top of my head. That might be wrong, but I think that's what that's saying. Right, okay. So, I might be wrong about that, but let me just read that through that again. Subsection 7. If the Secretary of State has not exercised the power under subsection 2, which is the power to make regulations extending the time, before the end of the period of 3 months, beginning with the day on which this act is passed, that's April, May, by June the 25th, this section ceases to have effect. This entire section ceases to have effect. Right? Which means that he can no longer do that. What has this got to do with the virus? I don't know, Tarquin. Maybe you could, okay, playing my devil's advocate hat, maybe it's to do with, I don't know, is the answer to that question. Right, regulations under subsection 2 may make different provision for different purposes, or makes consequential, supplementary, or transitional provision. Okay. I don't know what that means. Right. Regulations under. Oh, right. So. Oh, okay. Yeah. Right. So what that's saying is that any regulations that the Secretary of State enacts in extending a period that he can keep the DNA may also make different provisions for different purposes, or make consequential, supplementary, or transitional provision. Right? So I think that's basically saying if he does that, they can also slip in other stuff. Right? I think that's what that's saying. That's quite sneaky. Right, so a statutory instrument, subsection 9, a statutory instrument containing regulations under subsection 2 of this Act, of this section even, is subject to annulment in pursuance of a resolution of either House of Parliament. Right? So if either of the Houses of Parliament, the House of Commons or the House of Lords annuls this statute, a statutory instrument. Right, okay, no, yes, right. So, any statute that is created as a result of this statute is subject to annulment in pursuance of a resolution of either the House of Commons or the House of Parliament. Right? I think that's probably quite standard. So that's interesting. This is saying that it's kind of weird. Maybe this is normal. Maybe this is normal, this sort of stuff, when you're giving the Secretary of State powers to kind of create new rules. Maybe that's all kind of normal. I don't know. Yeah. All right, so that's interesting. Let's so it seems that the government are giving themselves the power to create new rules that allow them to retain biometric data for longer. What's this? Food supply. Power to require information relating to food supply chains. What the hell is this? Has this been changed? There are prospective changes. Right. This version of this provision is prospective. If I click on that, is that going to... The term provision is used to describe a definable element in a piece of legislation. All right, okay. An appropriate author. So this is subsection 25 of the Coronavirus Act. I'm just reading it because it seems kind of interesting. The power to require information relating to food supply chains. An appropriate authority, subject as follows, may, subject as follows, require a person who is in a food supply chain or a person who is closely connected with a food supply chain to provide relevant information to the authority. In subsection 1, relevant information means information about matters which relate to an activity of the person where the activity is connected with the food supply chain. Okay, right. So this kind of makes sense, I suppose. It's giving the powers in relation to protecting the food supply from the coronavirus. But what can they do? And this is prospective, so it's not... This is revised. Okay, so what's it actually... No, latest version, latest available. Right, so, okay, this is to do with whether the food supply is being at risk of being disrupted. So what does it mean? Do we want to look at this? No. Because it took us ages to get through. It took us ages to get through that. the last one about the DNA and the fingerprints, and I want to get onto the police. What the police can do. So let's move on now. Powers relating to gatherings and premises, and powers relating to potentially infectious persons. Now, the thing about statutory provisions such as this is that when you click on the thing, there's often nothing there, like here. And actually, it says, and where it says Schedule 21 confers powers relating to potentially infectious persons and makes related provision. What that means is that there's a whole huge section later on down here. And in fact, that's what we're going to start looking at now. We're going to look at some of these schedules. So, let us, oh my word. Overview and interpretation. All right, what are we going to look at? Let's collapse this. Right, let's see what the different parts are first. Oh, there's a lot in here, isn't there? Overview and interpretation. Overview, parts 2 to 5 of the schedule. What's that saying? So let's get review, and let's open you up. Right, parts 2 to 5 of this schedule confer powers on public health officers, constables. Oh, right, so it's not just the police. Parts 2 to 5 of the schedule confer powers on public health officers, constables and immigration officers in England, Wales, Scotland and Northern Ireland, and make related provision. The parts of this schedule contains provision relating to the interpretation of parts 2 to 5. Right, so let's that's fair enough. And let's have a look. Now, the definitions. What kind of tea do I have? I've got Yorkshire tea. Yorkshire tea. Now, I love this. This is so funny. It is so funny. It's so broad as to be laughable, but I kind of like it. It's funny. For the purposes of this schedule, a person is potentially infectious at any time if A, the person is or may be infected or contaminated with coronavirus, and there is a risk that the person might infect or contaminate others with coronavirus. So that's everyone. Thank you, Tarquin. Yorkshire tea. Yorkshire tea is great tea. Or the person has been in an infected area within 14 days preceding that time, which again is everyone, right? Because it's global now, yeah, right? I don't know, what's an infected area? For the purposes of this paragraph, infected area. Oh, right, there we go. Subsection 2. For the purposes of this paragraph, infected area means any country, territory, or other area outside the United Kingdom. Oh, right, okay. For which the Secretary of State has declared as a country, territorial area. Which the Secretary of State has declared as a country, territorial area. Where there is known or thought to be sustained human-to-human transmission of coronavirus, or B, from which there is a high risk that coronavirus will be transmitted to the United Kingdom. So the United States, for example, is an infected area, it would seem to me. And a declaration under subparagraph 2 is to be made by being published online and must, as soon as reasonably practicable, which is a great phrase, I love it, after it is made, also be published in the London Gazette. All right, I'm not going to go through what the ones for Scotland and Wales and Northern Ireland say, because they're saying basically the same thing, except they give different places where it's going to be published. So Scotland is the Edinburgh Gazette. What's Wales is going to be something else. Oh no, Wales is different. Well, okay, we might need to look at Wales separately. I looked at Scotland. I assumed Wales was going to be the same, but it's obviously not. So let's expand that. So that's England. So, all right, and let's just look at 1, 2. There we go. We'll look at Wales, Scotland, and Northern Ireland in a moment. In this schedule, okay. So again, we've got definitions, which is good. So. Right. So we've got assessment in relation to a person means assessment of the measures that it would be appropriate to take in relation to the person under the schedule or otherwise to mitigate the risk that the person might infect or contaminate others with coronavirus. Okay. I don't think we need to read through the definitions. Public health officer means public health officer. Right, okay. All right, we don't need to. That's fine. Well, that was just So here we go. Right, let's do England. Powers relating to potentially infectious persons in England. Declarations of risk of coronavirus in England. Let's have a look at this. So what I'm going to do from now on is just go use these next cross headings to navigate through. So this is, for those of us who have just joined, we're looking at the Coronavirus Act 2020, Schedule 21, Part 2, Declarations of Risks of Coronavirus in England. If at any time the Secretary of State is of the view that the incidence or transmission of coronavirus constitutes a serious and imminent threat to public health in England, that's A, and B, the powers conferred by this part of this schedule, of this act, will be an effective means of delaying or preventing significant further transmission of coronavirus in England, the Secretary of State may make a declaration to that effect. Okay. Right, so he's saying that he can declare the level of risk. If having made a declaration under this paragraph, the Secretary of State, if having made a declaration under this paragraph, the Secretary of State ceases to be of the view referred to in the sub-paragraph 1, the Secretary of State must revoke the declaration. So if he stops thinking that the coronavirus is an issue, he's got to say so. A declaration or revocation of the declaration. All right, here we go. So this is England, right? So yeah, must be published online and in the London Gazette. So I'm not going to go through Scotland. I might just to check, but we'll, you know. Right, the Secretary of State may make a declaration under this paragraph on more than one occasion, fair enough. And number 5, before or making or revoking a declaration under this paragraph, the Secretary of State must consult the Chief Medical Officer or any of the Deputy Chief Medical Officers of the Department of Health and Social Care. That's going to be different whether you're in Scotland or Ireland or Wales, because they're going to have different names for those people, for those offices. In this part of the schedule, transmission control period means a period which, A, begins when the Secretary of State makes a declaration under paragraph 4, which is the declaration that he may make under this paragraph on more than one occasion. Oh, right, no, this is paragraph 4, the whole thing. This is paragraph 4, sorry. Yeah. And ends when the declaration is revoked, fair enough. All right. The reason why, okay, paragraph 6. This is like reading the Bible, isn't it? Powers to direct or remove persons to a place suitable for screening and assessment. So this paragraph applies if, during a transmission control period, which we looked at in the last paragraph, a public health officer has reasonable grounds to suspect that a person in England is potentially infectious. The public health officer may, subject to subparagraph 3, direct a person to go immediately to a place specified in the direction which is suitable for screening and assessment, remove the person to a place suitable for screening and assessment, or request a constable to remove the person to a place suitable for screening and assessment. I think I want to look up public health officer. I want to look up what that means in this definition. So maybe it was important to have that open. Public health officer means, in part 2 of this schedule, any officer of the Secretary of State designated by the Secretary of State for any or all of the purposes of this schedule, or a registered public health consultant so designated. The same for the Scottish people and Welsh people. So a public health officer, so it's not a doctor necessarily. They're not saying that like it's a doctor or a nurse. It means that it's anyone that the Secretary of State states is a public health officer. Oh, that's so funny. That's so funny, because it's like, to a normal person, public health officer, they'd read that and they'd think, oh, doctor or nurse. That's kind of what I thought initially, doctor or nurse, or some other kind of ancillary. It's just, you know, that's me being an idiot, of course. You know, this is a statute, it's not English. Right, so, okay. Okay, right, so what we request a constable. So, a public health officer may exercise the powers conferred by this paragraph in relation to a person only if the officer considers that it is necessary and proportionate to do so, A, in the interests of the person. That's good. I like that. I like that they've put the interests of the person who is potentially infected first, for the protection of other people or for the maintenance of public health. Okay, that seems pretty straightforward. Where a public health officer exercises the powers conferred by this paragraph, the officer must inform that person, A, of the reason for directing or removing them, and B, that it is an offence. Here we go, this is quite interesting. That it is an offence, 1, in a case where a person is directed to fail without reasonable excuse to comply with the direction, or 2, in a case where a person is removed by the officer or by a constable to abscond. So, right, so this is quite important. Let's go through this again. Right, so if during a period of transmission control, as outlined in the previous section, where the Secretary of State makes a declaration, have I remembered that correctly? Let's go back. Yes, right. So if during a period when the Secretary of State thinks that the country is at risk of, you know, a coronavirus outbreak, I mean, I don't know how long, you know, hopefully this statute will be revoked soon. So, anyone that is designated as a public health officer may tell a person they suspect of being infected to go somewhere for assessment and screening, or ask a police officer to take them somewhere, right? Or take them somewhere themselves, if they think, you know, it's in the interest of the person and in the interest of public health and for the protection of other people. And the officer must inform the person, right? So the public health officer must inform the person, not a police officer, right? A public health officer, right? Of the reason for directing or removing them, and that it's an offence to fail to comply or to abscond. Okay. This paragraph applies if, during a transmission control period, a constable or an immigration officer, in the course of exercising any of their functions, has reasonable grounds to suspect that a person in England is potentially infectious. Right, so that's kind of interesting. Isn't everybody potentially infectious? Like, everybody is potentially infectious. Because even if you let's say you get the virus and you survive, like, can you catch it again? I'm not sure if you can. I don't think you can. I think you're then immune, aren't you? But you can still carry the virus. Right? You might be immune to the system, to the symptoms, but, like, you know, if you touch something and it's got coronavirus, then you're going to be transmitting the coronavirus, aren't you? Even if you're immune to it, right? So everybody is potentially infectious. That's really interesting. That's really interesting. Right, oh, this is a new paragraph, paragraph 7. Right, okay. Right. Paragraph 7. Section 2 of paragraph 7, the immigration officer or constable may, subject to subparagraph 3, which is following, Direct a person. Okay, so similar to the section before, you are immune for an indeterminate period of time. Right, okay, thanks, Tarquin. And again, it's the same. I mean, it's kind of the same provision, except it's an immigration officer in this. Right, so we've got the same. So Section 6 and Section 7 are basically the same thing, but one applies to public health officers, right, who is anyone that the Secretary of State states is a public health officer, and then Section 7 applies to police constables or immigration officers, right? So yeah, okay, so that's that. Let's move on. Okay, powers exercisable at a screening and assessment place, public health officers. Right, okay, so okay, this could be interesting. This is kind of getting into what the state can do once they've sequestered you away. So paragraphs 9 to 11 apply where, during a transmission control period, excuse me, a person is, all right, let's highlight this, whether or not pursuant to the exercise of the powers under this part of this schedule, at a place in England which is suitable for screening and assessment, and B, a public health officer has reasonable grounds to suspect that the person is potentially infectious. I mean, you've got reasonable grounds to suspect that everybody is potentially infectious. Everybody is potentially infectious. Doesn't mean that everybody is infectious, of course. But especially now, everybody is potentially infectious. Anyway, let's move on. A public health officer may exercise a power conferred by paragraphs 9 to 11 only if the officer considers that it is necessary and proportionate to do so. So this is the same as the previous section. Right. Public health officer may require the person referred to in paragraph 8 to remain at the place. Right, so this is the potentially infectious person. To remain at the place for screening and assessment purposes for a period not exceeding 48 hours. 2. Where a public health officer requires a person to remain at a place under this paragraph, the officer must inform that person, A, of the reason for imposing the requirement, B, of the maximum period the person may be required to remain there, and C, that it is an offence to fail to comply with the requirement. A requirement imposed on a person under this paragraph may be enforced by a public health officer or a constable keeping the person at the place. Paragraph 10. A public health officer may require the person referred to in paragraph 8 to be screened and assessed and impose other requirements on the person in connection with their screening and assessment. Requirements under subparagraph 1a may in particular include requirements on a person, A, at such times as the public health officer may specify, 1, to provide a biological sample, or 2, to allow a healthcare professional to take a biological sample by appropriate means. Did we look at what biological sample means? A biological sample includes a sample of blood or respiratory secretions, including a sample of such secretions taken by a swab of the nasopharyngeal cavity. Nasopharyngeal cavity? Nasopharyngeal cavity? Let's, I don't know what that is. Let's search for that. Oh, right, okay, so it's kind of at the right at the back of the nose. It's this part here where I'm hovering my mouse, this purple bit. Right, okay. Let's continue. Where was I? Right, okay, so requirements under subparagraph 1A means that if you're asked to by a public health officer, you have to give a biological sample. Right, in subparagraph 2A2, healthcare professional means a registered medical practitioner, a registered nurse, or such other registered healthcare professional as may be designated by the Secretary of State. That's certainly what it sounds like, Tarquin, here. Right, requirements under subparagraph 1B. Right, so this is, I think, impose other requirements on the person in connection with their screening and assessment. Requirements under subparagraph 1B may in particular include requirements on a person, A, to produce any documents which may assist in their assessment. Presumably that includes identification. Interesting. Any documents. Or B, to provide details by which they may be contacted during such subsequent period as the public health officer may specify. Right, okay. That's interesting. So basically, other requirements basically means provide documents to them. And to provide contact details. Paragraph 11. If a public health officer considers it appropriate for the purposes of screening or assessing the person, the officer may direct the person referred to in paragraph 8 to go immediately to another place which is specified in the direction suitable for those purposes. Is this the right tab? Am I in the right tab still? Yeah. Right. Sorry, see, this is the thing about statutes, is that often they're quite repetitive because they cover every single base. If a public health officer considers it appropriate for the purposes of screening or assessing a person, the officer may direct the person referred to in paragraph 8 to go to another place, to remove the person there, or to request a constable to remove them. Where a public health officer exercises the power conferred by this paragraph, the officer must inform that person of the reason why, and that is an offence to not do what they say. All right, as we've read previously. So where are we up to in this? That is right. Powers exercisable at a screening and assessment place, constables and immigration officers. So I think this is the same. Right, okay. This applies at I'm getting powers exercisable at, okay, no, let's do it. We got to go. We are doing it. We're doing it. We're going. It's a deep dive, so we're diving deep. We're diving deep into the nonsense. Okay, what is this? Powers exercisable at a screening and assessment place. Control and immigration officers. This is what the police can do. Constables and immigration officers. Right, so this paragraph applies where? During a transmission control period. A person is at a place suitable for screening, and the police officer thinks they might be infectious. The officer might keep them, subject to paragraphs 3 and 6, at that place until a public health officer can exercise the functions under paragraphs 9 to 11, which we've gone through already in relation to that person. Right? Okay, so this is when the public health officer gets a constable, like say if someone kicks off, right, and whoever the public health officer is like they're not used to dealing with people kicking off, so they get a copper and they say, can you take, you know, this nutter to the testing place? This is what the police can do as they're doing that. So a person cannot be kept by a constable for a period exceeding 24 hours or by an immigration officer for a period exceeding 3 hours. Okay, so this is quite good. I'm actually pleased this is here. I was like, the reason that I paused earlier because the public health officer, they can detain people for up to 48 hours, right? But I think the police can only detain someone for 24 hours or they have to charge you with a crime, right? So that's why this is in here, okay? But they've kind of gotten around this by saying that, you know, anyone that there's can be named as a public health officer. You know, the copper. Yeah, okay, anyway, let's carry on. If before the end of the period referred to in subparagraph 3A or B, the immigration officer or constable considers that it is necessary to extend the period because it is not reasonably practicable for a public health officer to exercise the functions under paragraph 9 to 11 before the end of that period, the officer or constable may, with the consent of a relevant officer, extend the period for a further 24 hours in the case of keeping by constable, or 9 hours in the case of keeping by an immigration officer. And in this context, in subparagraph 4, relevant officer means a constable of the rank of superintendent or above in the case of a keeping by the constable, or an immigration officer not below the rank of chief immigration officer in the case of keeping by an immigration officer. Right? So I don't know. Okay, so basically a superintendent, police ranks. Let's have a look. Police rank UK. Superintendent is, I think, is pretty high up the chain of command. Oh, maybe not. No, yeah. Okay, yeah. You got constable, sergeant, inspector, chief inspector, superintendent, and chief superintendent. And I suppose they're up to chief superintendent. So superintendent, in terms of the rank and file, is quite a high rank. Right? You know, it's 1, 2, 3, 4 ranks above a constable. Okay, where are we? Oh, have we done? We've definitely done that, haven't we? Oh, that's the definition of the page. That's why. Right. And then we've got the usual stuff that we've had in every. I'm not going to bother reading this again because that's just. It's going to be the same for every section for those things. So I'm going to start skipping over the more repetitive stuff. Right, so after you've been assessed, during a control period, if it's been confirmed, alright, so if you're in England and you've been screened and assessed, if it's been confirmed that you're infected, or the screening was inconclusive, alright, or a person in England has been assessed by a public health officer under paragraph 10 or otherwise, and the officer has reasonable grounds to suspect that the person is potentially infectious. So that's when this applies. Right. Again, interests. I'm going to skip this. We don't need to read that. We've read that so many times. Requirements under this paragraph may include requirements to provide information to the public health officer for any specified reason, to provide details by which the person may be contacted. Okay, again, that's similar. To go for the purposes of further screening and assessment to a specified place suitable for those purposes. Excuse me. And to do anything that may be required under paragraph 10.1. To remain there for a specified period. And to remain in isolation for a specified period. Restrictions on a person under this paragraph may include restrictions for a specified period on movement or travel within or outside the UK. Their activities, including their work or business activities, and their contact with persons or with other persons. All right, again, we got some of the stuff why they're doing it. That to fail to comply is an offence. Right, so the public health officer must have a regard if they're going to detain someone further. They must have, because they think that they might still be, well, because they're infected or they think they might be infected. They must, have a regard to the person's well-being and personal circumstances. Okay. I mean, does that... Right, okay. Right. A public health officer may vary or revoke a requirement or restriction imposed on a person, but may only extend the period to which a requirement referred to in sub-paragraph 3D or E, or restriction... Oh, Jesus Christ. Or restriction relating in accordance with paragraph 15. Right, paragraph 15. What is this? Okay, so paragraph 15. So it doesn't say how long you're meant to be in isolation. Maybe that's determined by the public health officer. The period specified in relation to a requirement referred to in paragraph, okay, or in relation, right, may not exceed 14 days. Okay. Right. After the imposition of a period, or after the imposition of a requirement, so we're on paragraph 15, section 2, paragraph 15. After the imposition of a requirement to remain or a restriction under paragraph 14, a public health officer must A. assess the person within 48 hours, and B. in the light of that assessment, reconsider which requirements or restrictions it is necessary and proportionate to impose on that person under paragraph 14 for the purposes referred to in paragraph 14.2. Right, so so what they're saying is that after the 14-day period, that period could be extended after the imposition of the period to remain in isolation. Within 48 hours, the person must be assessed, and then a decision must be made whether it's necessary to keep them in isolation still. The public health officer may, following reconsideration under subparagraph 2, revoke the requirement to remain or restrict or the restriction, or specify a different period not exceeding 14 days in relation to it, or substitute a different requirement or restriction under paragraph 14. Right. If under subparagraph 3 the public health officer revokes requirement to remain or the restriction, the Secretary of State may, if satisfied that the person is potentially infectious, reimpose a requirement or restriction. Right, okay. So they're just covering their bases here. So what, except in the cases... Right, okay. Except in the case of a requirement referred to in paragraph 14.3e, so we can't skip anything really. If before the end of the period specified in relation to remain or restriction, under paragraph 14 subsection 3 or subsection 3 or subparagraph 3a, a public health officer reasonably suspects that the person will be potentially infectious at the end of that period, and b, the officer considers that the requirement or restriction is still necessary and proportionate for the purposes referred to in paragraph 14.2. The officer may extend the period for a further specified period. Right, so if the public health officer thinks that the person still isn't infectious, they can extend it for a specified period, which is 48 hours, I think. Is that correct? Except in the cases of a requirement referred to in paragraph 14.3e, requirement to remain in isolation, the further period specified under subparagraph 5 may not exceed 14 days. Oh my god, this just goes on forever. So they can keep you in for a further 14 days. We haven't even got to the bit I wanted to talk about yet. This has been, what we're on, 104 minutes. I've been reading this shit for nearly 2 hours. We haven't even got to the bit that I want to talk about yet. Okay. Right. Okay, eventually my brain starts turning to mush. So this is kind of interesting, but I want to get to the thing that I was kind of wanting to, powers in relation to events, gatherings and premises. Because that's all powers in relations to potentially infectious persons, and that's interesting. And maybe we can come back and look at that, because you know, who knows when this will be repealed, if ever. But I might need another cup of tea. My mouth is dry. I've been talking for quite a long time, and this is kind of dull and boring, and so I actually also need a quick kind of break from talking about this. So I'm going to choose another lovely tune for you, and I'm going to go and make a cup of tea, and I suggest that maybe you do the same thing, and then when I come back, finally we'll get into what powers the police have. All right. Hopefully you weren't waiting too long for me to get back. So, back into our deep dive on the Coronavirus Act 2020. So so just to recap, in case you've just joined the stream, we've looked at quite a lot of stuff. It takes quite a long time kind of unpicking what's actually being said, because it's not written in a language that's conducive to ease of understanding. Now, what I want to get to, let's collapse Schedule 21, which is powers relating to potentially infectious persons. And I want to get on to Schedule 22, which is powers that relate to gatherings and like social distancing. Well, that's interesting. Transportation, storage and disposal of dead bodies. Maybe we'll look at that at the end, just for some macabre fun. Right, okay. Let's go. Let's do it. Part 1, general. Oh, that's my let's go back and Schedule 22. Let's open that in a new tab. Let's close you. Let's close you. Okay. So just to... Oh, you can't see the screen. All right, sorry, Tarquin. So just to recap what we've looked at so far. We have looked at the meaning of the coronavirus and the related terminology. We have looked at, very briefly, well, not very briefly, it took quite a while actually, the fact that they can extend warrants longer than they used to be able to, and they can retain DNA, or the Secretary of State can enact legislation to extend the period of time for which they can keep DNA profiles. And then we've kind of looked at some of the powers that they have in relation to potentially infectious persons, and that's taken quite a long time. So now we're going to start looking at the powers that people have, the powers that the police have in relation to just people. Now, if you've just joined the stream, in fact, let's for a bit of context, just to give those new people to the stream, let's replay this video of the former Supreme Court Judge Lord Sumption discussing the police in Derbyshire.
The police are naming and shaming citizens for travelling at what they see as the wrong time or driving to the wrong place. Does that set alarm bells ringing for you as a former senior member of the judiciary?
Well, I have to say it does. I mean, the tradition of policing in this country is that policemen are citizens in uniform. They are not members of a disciplined hierarchy operating just at the government's command. Yet in some parts of the country, the police have been trying to stop people from doing things like travelling to take exercise in the open country, which are not contrary to the regulations, simply because ministers have said that they would prefer us not to. The police have no power to enforce ministers' preferences, but only legal regulations, which don't go anything like as far as the government's guidance. I have to say that the behaviour of the Derbyshire police in trying to shame people into using their undoubted right to travel to take exercise in the country and wrecking beauty spots in the fells so that people don't want to go there is frankly disgraceful. This is what a police state is like. It's a state in which the government can issue orders or express preferences with no legal authority, and the police will enforce ministers' wishes. I have to say that most police forces have behaved in a thoroughly sensible and moderate fashion. Derbyshire police have shamed our policing traditions.
Thanks, Tarquin. You'd think after all this time, after all this bloody time, you'd think I'd know how to do this, wouldn't you? You'd think I'd know how to do something as simple as unmuting my microphone. Well, that's what you get with me. Professional streaming. Right, okay. Let's get into this then. If at any time the Secretary of State is of the view that A, the incidence or transmission of coronavirus constitutes a serious and imminent threat to public health in England, and B, the powers conferred by this part of this schedule will be an effective means of 1. Preventing, protecting against, delaying or otherwise controlling the incidence or transmission of coronavirus in England, or 2. Facilitating the most appropriate deployment of medical emergency personnel and resources in England, the Secretary of State may make a decision to may make a declaration to that effect. Okay, so he can. This is saying that he can make a declaration that the coronavirus constitutes a serious and imminent threat to public health. If, having made a declaration under this paragraph, the Secretary of State ceases to be of the view mentioned in the subparagraph 1, the Secretary of State must revoke that declaration. A declaration or revocation of a declaration under this paragraph is to be made by being published online and must and B must as soon as reasonably practicable after it is made also be published in the London Gazette. Now that differs. This and also right then we've got this stuff about speaking with the conferring that the Secretary of State must consult the Chief Medical Officer. Now that differs according to the countries. So if I come down to relating to events and premises in Scotland, well, let's go Wales. And what section are we on? We're on Part 2, Schedule 22, Part 2. Declaration of Threat. Declaration of Threat. So let's have a look at, is that England still? No, that's England. I'm an idiot. Scotland. So I think essentially it's exactly the same for Scotland. Wales, sorry. There we go. Except, obviously it applies if it's Wales, it's a threat. They must revoke it as previously stated. It must be published online, or must, as soon as reasonably practical after it is made, also be published in a newspaper in general circulation in Wales. Right. It's details like that in which it differs from England. Okay. Okay, for the purposes of protecting against the transmission of coronavirus, delay. Oh, right, let's read it out properly. Stop paraphrasing. Okay, so paragraph 5. The Secretary of State may, for the purpose of A, preventing, protecting against, delaying, or otherwise controlling the incidence or transmission of coronavirus. Well, that's interesting. That's interesting. Otherwise controlling. Like, am I the only one who finds that weird? Otherwise controlling. What control other than prevention, protection against, or delaying would you want to employ with the coronavirus? Surely that's not going to allow them to I don't know, use the coronavirus. That would be mental, wouldn't it? All right, anyway, let's carry on. Or B, facilitating the most appropriate deployment of medical emergency or emergency personnel and resources. So for those purposes, the Secretary of State may issue a direction prohibiting or imposing requirements or restrictions in relation to the holding of an event or gathering in England. A direction under subparagraph 1 may be issued in relation to A, a specified event or gathering, or B, events or gathering of a specified description. A direction under subparagraph 3. A direction under subparagraph 1 may only have the effect of imposing prohibitions, requirements, or restrictions on A, the owner or occupier of premises for an event or gathering to which the direction relates. B, the organizer of such an event or gathering. Or C, any other person involved in holding such an event or gathering. Okay. So this all seems pretty straightforward. 4. A direction under subparagraph 1 may only be issued during a public health response period. 5. A direction under subparagraph 1, among other things, may, among other things, impose requirements about informing persons who may be planning to attend an event or gathering of its prohibition or any requirements. So this is relating to large events. I kind of want to get to... Alright, the reference in subparagraph 3c. This doesn't apply to people going to the events anyway. It applies to event owners. Okay. Power to close premises or impose restrictions on persons entering or remaining in them. So, for the purposes that we've already outlined, I'm not going to read that again. Under subparagraph 1, which is, if there's a coronavirus issue, a direction under subparagraph 1 may be issued in relation to a specified premises or premises of a specified description. So the previous paragraph was about events, right? So the government can now prohibit or restrict events. I mean, that's quite strong. That's quite... I mean, this is all kind of unknown territory, really. Okay. The Secretary of State may... Right, okay, so, sorry, I'm having a brain fart because this is kind of quite tedious to read through and try and understand and pick apart. Right, a direction under subparagraph 1 may be issued in relation to A, specified premises or premises with a specified description. A direction under subparagraph 1 may only have the effect of imposing prohibitions, requirements or restrictions on the owner. Right, again, so, or any, on the owner, or any other person involved in managing the entry into or departure from such premises or the locations of persons in them, right? So like these restrictions apply to, say, like a bar owner or bouncers, right? Okay. A direction under subparagraph 1 may, among other things, impose requirements for the purpose of closing the premises, restricting entry to the premises, or securing restrictions in relation to the location of purposes in the locations of persons in the premises, right? So that's saying under this provision, the premises could be closed. They might restrict entry into the premises to only certain times of the day, or they might restrict where people can be inside the premises. And subparagraph 6, a direction under subparagraph 1 may impose prohibitions, requirements or restrictions by reference to, among other things, the number of persons in the premises, the size of the premises, the purpose for which a person is in the premises, the facilities of the premises, or a period of time. Right, so those are what can be restricted, right? So they could say, okay, you can only, in premises that are smaller than, I don't know, 20 square feet, you can only have 3 people, right? So let's move on. Variations and revocations. The Secretary of State may vary or revoke to any extent a direction issued under this part of the schedule. All right, that's pretty straightforward. Right, okay. What I might do is just quickly scan through, because this is about what the Secretary of State must and mustn't do. So I might just quickly scan through them without reading them out. I kind of want to get to the meat of what I want to talk about, or at least offences. Here we go. A person commits an offence. Okay, so this is going to be subparagraph 9 of Schedule 22, Part 2. Paragraph 9, subparagraph 1. A person commits an offence if the person fails, without reasonable excuse, to comply with a prohibition, requirement, or restriction imposed on the person by a direction issued under this part of this schedule. A person guilty of an offence under this paragraph is liable, on summary conviction, to a fine. Paragraph 10, subparagraph 1. If an offence under paragraph 9 committed by a body corporate is proved A, to have been committed with the consent or connivance of an officer of the body, or B, to be attributable to any neglect on the part of such an officer, the officer, as well as the body corporate, is guilty of the offence and liable to be prosecuted and proceeded against and punished accordingly. In paragraph 2, in subparagraph 2, in subparagraph 1, officer in relation to a body corporate means a director, manager, secretary, or other similar officer of the body corporate. By secretary, I don't think that means the woman who might take your notes and that. Enforcement and prosecutions. So, paragraph 11, subparagraph 1. A person, or description of person, designated in writing for the purpose of this paragraph by the Secretary of State may take such action as is necessary to enforce compliance with the direction issued under this part of this schedule. Right, so a person who's stated that they can take such actions are enabled to take such actions. Proceedings for an offence under this part of this schedule may be brought by a person or description of person. I wonder what that means. I don't know what that means. Designated in writing for the purpose of this subparagraph by the Secretary of State, and the powers conferred by or under this paragraph do not affect any other power to enforce compliance with a direction issued under this part of the schedule or to bring proceedings for an offence under this part of this schedule. Oh my God, it's gibberish. It's gibberish. The powers conferred by or under this paragraph do not affect any other power to enforce compliance with a direction issued under this part of the schedule or to bring proceedings for an offence under this part of the schedule. Okay. All right, have I understood that? Do I understand what that's saying? Enforcement and prosecutions. I don't know what any of this means. A person designated in writing for the purpose of this subparagraph by the Secretary of State may take such action as is necessary to enforce compliance with a direction issued under this part of this schedule. Okay. End of public health response period. Right? No, I don't want that. Scotland. So, okay, it says it's an offence. I can't see anything in relation to being fined. Powers relating to... I don't understand. Have I missed something? Right, let's have a look. Short title. Yada, 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 yada. Procedure. No, 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 no. Power to make consequential modifications. No, 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 no. Right. Let's collapse final provisions. Oh, this is interesting. Postponement of elections. I mean, that's something else that could be looked at. That's another interesting thing. But I want to... Events and premises. This is the Coronavirus Act, right? Is this not the thing that gives people the ability to fine? I don't understand. Coronavirus. Penalty notice. All right, let's have a look. Right, to ensure that people stay at home and avoid essential non-travel from today being the 26th of March, so the day after that statute was passed into law. So the police may instruct them to go home, leave an area. Right, okay. Right, no, I get it now. I get it. It's not in the statute. It was actually really good. We read all that stuff beforehand where it wasn't directly it wasn't directly related to breaking the law, right? So all that stuff where it was saying the Secretary of State may make new rules, right? May issue like an edict. This is it. This is what that means, right? So there isn't a law, there isn't a statute that says that there's a fixed penalty notice of £60, right? He's just said there is. Oh my word, that's mental. That's crazy. That's fucking crazy. That is mental, right? So the Home Office, okay, so this is interesting. I mean, I sort of get it. I kind of understand why they're getting it, but like it is a bit nuts, right? So the Secretary of State has said that the police now can instruct people to go home, to leave an area or disperse, right? That they can issue a fixed penalty notice of £60, right? Issue further fixed penalty notices, doubling on each further repeat offence. If you don't pay them, they can be taken to court, with magistrates able to impose unlimited fines. If an individual continues to refuse to comply, they will be acting unlawfully, and the police may arrest them where deemed proportionate and necessary. Notice they're not saying illegally. I wonder why that is. There's a group of people called Freemen on the Land, and they make this huge distinction between lawful and legal, right? Personally, I think it's just kind of word wankery. But it's interesting that the government is saying if you don't comply, that's unlawful rather than illegal. However, in the first instance, the police will always apply their common sense, right? So they don't have to see, because it's interesting. I was reading that statutory provision, the Coronavirus Act 2020, right? Because I wanted to see what powers the police had. Well, these are the powers, right? The Secretary of State just says the police have these new powers. What have you got there, Tarquin? Article linked to by Tarquin. Okay, well, this is interesting. Let's have a look at this. The Mail Online, not the most reputable of rags, but I know there's only 4 people watching, but do the people watching understand what I'm saying? The Coronavirus Act 2020 doesn't give the police the right to issue fixed penalty notices, right? It doesn't give the police the authority to tell them to go home or to disperse, right? What it does is it gives the Secretary of State the right to issue a declaration, and then that declaration is legally binding, right? So it gives the Secretary of State the right to say, in order to combat the coronavirus, all these new regulations are now going to be in place, right? And that doesn't, they don't need to pass, that's crazy, that's crazy. It means that if he wants to introduce a new crime now in order to combat the coronavirus, like, does that mean that he can just draft a new statute? I don't know. But anyway, let's look at this. Britain's first conviction for, let's close you, I don't know what you are, for breaching lockdown was illegal. But was it unlawful? Bungling police used the wrong law to fine a 41-year-old woman £800 when she refused to say why she was at Newcastle Station. Marine Dinu, 41, from York, was arrested by a British Transport Police. Who's there, like some ghetto journalist working at the Mail? Yeah, man, I was arrested by a police, you get me? Found loitering between platforms. What, on the tracks? Charged with failing to comply with requirements of the Coronavirus Act 2020. But lawyers say officers used the wrong law linked to people who are infectious. Right, okay, let's have a look. Police today have been accused of using powers they don't have to arrest a woman at a police station as overzealous enforcement of new coronavirus laws. Well, there's only one law, right, which is the Coronavirus Act 2020. Came under the microscope again today. Marie Dinu, 41, from York, was fined £800 after allegedly failing to tell the police her name and why she was at Newcastle's Central Station, and is believed to be Britain's first prosecution for breaching the lockdown. British Transport, I mean, that's interesting. Like, I do think this is quite big, all right? Now, I'm not a freeman on the land, but I think the right to tell a police officer, like, to basically tell a police officer to sod off if he's being a knob, is actually really important. But anyway, British Transport Police who carried out the arrest said she was detained because she refused to speak to officers after being seen loitering between platforms. She was fined at North Tyneside Magistrates Court on Monday. She was fined at North Tyneside Magistrates Court I mean, whoever wrote this is an idiot. After she was found, I mean, you know, do you not have an editor to read this stuff? After she was found guilty of failing to provide identity or reasons for travel to the police and failing to comply with the requirements of the Coronavirus Act. But legal experts say that it's the wrong law. Well, yeah. Do not relate to a direction to provide identity or a reason for journey. I mean, to be honest, her lawyer is fucking shit. If she was convicted, right, of this, she was convicted and her lawyer, right, okay. You failed, yeah, like her lawyer should have picked up on this during the court case. Right, so what's yeah, and the emergency regulations, right? So they have powers under the emergency regulations. The Coronavirus Act, yeah, is is different. She was prosecuted under Schedule 21 of the Coronavirus Act. Schedule 21 relates to powers relating to potentially infectious persons. So is she not potentially infectious? Right, okay, so this is, yeah. Right, so this is going to happen a lot. I think if you're from the UK, and the police start hassling you under, they ask for your name and address and what you're doing, you should ask them, well, do you suspect me of having the coronavirus? If they don't have the right to ask you for that information. Right, the Police Chiefs Council, the National Police Chiefs Council, is clear that under the Act, officers have no power to stop an account or force someone to explain themselves. Right, so that video of those coppers that we watched earlier, where they're asking did they drive there and stuff, they can't do that. They've got no authority to do that. Fuck the police. You're right, Tarquin, fuck the police. Loitering between platforms, what the hell does that mean? Like, if you're waiting for a train, you're going to be loitering, aren't you? Like, come on. Geordie Coppers, what the fuck are you playing at? So here we go. See what I was saying? I did bring this up earlier. Others have claimed that Mrs. Deener's case suggests police can now treat suspects as potentially infectious to perform arrests, right? Which is probably what they're going to start doing. Potentially infectious. Right, okay, so there we go. Big Brother Watch doesn't appear to understand what the Coronavirus Act does. It doesn't give police huge powers to arbitrarily find, detain and punish potentially anyone in this country. It gives the Secretary of State the power to enact such regulations, right? And that's a really important distinction, because what it actually does is far more kind of insidious, I think, far more dangerous. I think I'll be quite pleased when this statute gets repealed. I hope it is repealed soon after this, things passes. Let's make that smaller a bit. And it's interesting, following Deener's arrest, British Transport Police said enforcement action like this was always a last resort, and officers would always try to engage with passengers and convince them of the need to follow the advice before taking matters further. What about, see, I don't like authority figures, and I sort of don't like bully boys at all. And a lot of coppers are bully boys. Right, this has been going for 2 hours. I'm going to stop now, I think. My tea is finished. I don't know what else, that there's much more that I can say, really. So I think, let's do a kind of outro. Let's do a closing thoughts. I should have a little thing flash up on the screen. I need to be more professional. Closing thoughts. Right, so the coronavirus doesn't actually give the police... I mean, it does. It gives the police powers to detain people in certain contexts if the Secretary of State has made certain declarations. Right? It doesn't give the police the right to arbitrarily, just kind of move you on. It doesn't give the police the right to, unless they suspect you of having the virus. And it could be that this is a thing that we see more and more of, where people are arrested as being potentially infected. But it does give, if the Secretary of State makes a declaration of a threat to public health, which I'm guessing he will have done, it's interesting that the new regulation, what this does is it gives the Secretary of State the right to enact new regulations without having to kind of go through the whole palaver of drafting a new, Act of Parliament, right? So normally you can't just say that you can be fined for refusing to, vacate a public space, right? you know, assuming it's not a crime scene or whatever. But now, well, they can, you know, the Home Office can just say, right, well, you know, if a copper tells you to leave, or if a copper tells you to go home and you don't, you can be fined. Right? That's really interesting. It's really interesting. Oh, that's kind of clever, right? That is clever. So anyway, I hope you enjoyed this deep dive into the Coronavirus Act 2020. I hope I've been able to tease some kind of meaning out of it. A lot of it is kind of gibberish. You just have to go through it word by word just to kind of, you know, get the sentence. Make sure you understand the sentences. I wouldn't say that I fully understood everything that was said, because I don't speak this sort of language normally at all. It's not, you know, we're not in a police state. It would seem that what Derbyshire Police were doing was actually outside of their remit. You know, shaming people using drones. And actually, I think what those other coppers were doing in kind of stopping people and asking them, like, did they drive there? It's like, well, it's none of your goddamn business. You know, now sod off. Anyway, I think that's what you lot should do. You should all sod off. I'll see you next time.